How common is it that enforcement of a family court order is needed in contested divorce cases?
I would say it's a relatively common thing. The percentages vary. Hopefully, you do the settlement agreement right, and the parties are able to live with that, and they're not forced to come back to court. The most common enforcement application is around money. So a lot of times it's the fathers that owe child support and they either fall behind or they don't pay or they lose their job or whatever, but then they forget to make their modification application. And then the mothers will need to file violation or enforcement cases. So that's more common than enforcement around custody, visitation, or property. Custody and visitation enforcement does happen. So examples being somebody withholds a child in joint custody cases, you could file an enforcement because somebody just doesn't follow that which was written into the agreement. They just kind of go off on their own and make decisions on their own or cut out the other party out of the decision-making process, in which case either an enforcement or modification application needs to be filed. Every once in a blue moon, you'll see applications come in around property or assets that were part of the decree. So examples being somebody was supposed to give the other side money or transfer ownership of a house or transfer investment accounts or retirement accounts or whatever, and they don't do it. So then the side that's owed the money or the property or the house or whatever needs to file an order to show cause, which is a type of motion before the court to enforce that application. So the key thing there is if the person who is alleged to violate is found to have violated, they generally have to reimburse the attorney's fees of the person filing the enforcement or violation application. So that's sometimes key to keep in mind.